So the election date is set, but are we stuck in the rut as far as the push and pull from NASA and Jubilee is concerned over Iabc? And this morning, I want to introduce our panelist. We have with us Miguna Miguna, who is a consummate lawyer. Also, we do have with us Dr. Agnes Zani. She is the Secretary General of ODM. We have with us Dr. Otiende Amollo, who is the Member of Parliament for Rarieda. And also we have with us Senator Kimani Wamatangi, Senator Kiambu. We're eagerly waiting for Mithika Linturi as well to join us much later, who's a senator from Meru. Good morning, gentlemen and lady.
Good morning.
Right, let's begin with you, Miguna Miguna. So far, looking at the double speak that is coming from Jubilee, speaking from both sides of the mouth as far as the judiciary is concerned. Last year, they were hailing the judiciary. This year, they're casting aspersions on judiciary.
Let me first of all say that I wish to express my condolences to the family of the bereaved children that died in Nairobi.
Yes.
And in Kisumu, the two schools where there were fires and there were fatalities. And obviously it is quite unfortunate that none of our public leaders went to the school, like the ones holding public office. The president didn't go, the deputy president. Many of these leaders never bothered. They just had their handlers issued statements. Having said that, coming back to your question, it is completely disgraceful, unacceptable, and amounts to disrespect for the people of Kenya, the Constitution, the judiciary, and the offices that they hold, that the President of the Republic of Kenya and his deputy would stand on podiums on days on end and abuse, insult, and threaten the judiciary, particularly the Chief Justice and the court that rendered judgment that was not in his favor. The president committed two serious crimes, in my view. One, a crime against statecraft. A president of a republic does not behave the way the president of the Republic of Kenya did. You don't appear in public drunk, visibly drunk, slurring, moving from side to side, incoherently attacking the Chief Justice in person and the entire court because you disagree with the decision. It was lacking in dignity, it was lacking in thought, it was lacking in judgment, and he actually disqualified himself to be fit for the office of the President of Kenya, including his deputy. Now, the second thing I would like to say is that the President and his deputy acted in violation of the Constitution, and I will later go to several provisions of the Constitution that the President and his deputy violated. The supreme law of the land is the Constitution, not the President of the Republic of Kenya. That is the supreme law. Supremacy vests in the Constitution, not in the executive. Now, sovereignty vests in the people, and it can only be exercised by the executive on behalf of the people. They hold their offices in trust for the people. He has no power at all to order the judiciary to do anything. And if he fails when he is in court, and like he did in this case, in this petition, he should not take it on the judiciary. He has no power to disband anybody. He has no power to fix anybody because he has no power to adjudge anything except to exercise power vested in him pursuant to the Constitution. As of now, this president is an acting president. He is not a legitimately elected president. So we must be very clear about that. And even if he was to be re-elected, assuming that these elections took place, and he's working very hard not to be re-elected, because threatening the judiciary is not actually how you get re-elected. So he's working very hard, and I'm happy that he's working very hard not to be re-elected. because from what he has demonstrated, he's not fit. So, assuming he's re-elected, assuming there is a magic and this man is re-elected, who is going to swear him in?
Good question.
The same Chief Justice.
The same Chief. Yeah, let's leave it at that. Let's hear from Dr. Agnes Zani. Your reactions on
yes. Thank you, and I'll just speak it from where Miguna Miguna left. Who is going to swear him in? Because I think it's important to respect. And from the clips that you showed, it's very clear that they're speaking from both ends of their mouth, contradicting themselves. When it suited them in 2013, when they were given the presidency through the Supreme Court, they were very happy about it. But I think Kenyans have been shocked at the level of carelessness in which the judiciary has been attacked. The judiciary represents the people. The judiciary also is an independent arm, like the legislature and the executive. And I think this begins to show the level of leadership that we have in some of our African countries. Because if somebody feels that they can dot it on another arm of government, I think it really portrays some sort of fear that people should have, the level of control that is expected one person to control. And I think for a long time, this sort of independence has never been there. And therefore, it's really taken for granted that one arm, especially the executive, and I think for a long time, the executive led by the Jubilee government has twisted and pushed the legislature, has pushed also the judiciary. But for the first time, we have a brave, strong man of Kenya who was able to stand and do the right thing. The prayers were very, very clear. The judges retreated and made their judgment. That is a judgment that needs to be respected. The comment about Nimekalia has to be put in the context of the timing. We went to an election on 8th of August. That marked the end of one regime and hopefully the beginning of another. Now that did not happen because we had to go to court. The Constitution is very clear about the powers of the president who comes into step as we move on to actually elect a president. So I think this show of power, show of I will do this and the other is actually misplaced, because at that particular point, the Constitution also dictates very, very clearly that one, for example, cannot hire certain officials, one cannot fire. The independence of the judiciary, executive, and legislature must be respected. And the points that have been put across to actually say there's a problem, Debarl, are issues we've discussed forever here. Looking at the Iabc and the way they conducted the elections really leaves a lot to be desired. So when people are talking about leadership and the change that is required and trying to get the right leaders into place, it is very, very unfair.
But the right Honorable Raila Odinga as well is not really off the hook as far as we're concerned, also casting aspersions on the judiciary. We've had him on record really also castigating the judiciary.
Yeah, but then I think really
so both sides of the divide are holding the skunk.
But you see, we're talking at the level at which we're having a president who is really to yet give the baton to another, actually directly attacking the judiciary and pointedly saying, you know, it's different to say, I think the judiciary didn't go this way. It's different to say, I'm going to deal with you. When I come back, that is a direct threat, and that's completely different from somebody who is perceived to have that power to do that, yet they do not have the power to do that.
Right, let's hear from Dr. Otiende. Are we facing the hallmarks of maybe a regime that is authoritarian somewhat?
I'm afraid the answer must be yes. And I am more afraid of the things that have not been said. The judiciary is one of the 4 pillars of government in our constitution. We have the executive, we have the legislature, we have the judiciary, and then we have other independent officers. With the situation we are in right now, the executive, the current regime of the executive has shown that it can ride roughshod over the legislature. It can call its senators and members of parliament and direct them that your speaker will be so-and-so, the Honorable Lusaka, and they abide. Your speaker will be the Honorable Justin Muturi, and they abide. It can call its members to threaten independent office holders. You heard Murkomen say, we know who are the commissioners who are sympathetic to the other side. Commissioners and independent office holders don't sympathize with anyone. They execute the office. So the judiciary stands as the last bastion of democracy. If you attack it, if you diminish it, if you cause it to cripple, then you are back to total authoritarianism. And what must be said is this. First of all, Article 73 of the Constitution is very clear, and the President should be the first citizen to observe it. Any holder of public office must conduct themselves with dignity in a way that brings respect to the office, and in a way that brings confidence in the office. The kind of conduct we've seen of the president lately does not inspire confidence. But more importantly, I think what ought to be said more than anything else is the pretense that we see. The pretense from the presidency, the pretense from religious society, the pretense from professional organization, who were the first to call. In 2013, they were the first to call Raila that accept and move on. In 2017, before elections, they insisted that if anybody has a dispute, go to court. Raila goes to court, and then the court decides that we must start fresh elections. What do they now say? That court comprises of thugs, that they will fix them. It means all those who are saying that were saying that the court is only an option as long as it rules against Raila. That cannot be fair. The court must remain respected whether it rules for you or against you. And one last thing, in fairness, and I've heard you say this, Debarl, that even Raila is on record as having attacked the judiciary. I want you to go back to what Raila said in 2013 when the court ruled against him. In very tempered words, he said, I do not agree with this court, but I will respect its decision. That is what he said. What did President Uhuru say? President Uhuru started by saying, I don't agree, but we will respect. But he didn't stop there. He's gone on to call the judiciary all sorts of names. A judiciary which comprises the Chief Justice who must swear in the President. A judiciary which all of us must rely on to resolve our disputes. Once we crash the judiciary, then we are left to other devices. And that would be very unfortunate.
But what would you say if the statement that also rolled off his tongue, that we are giving the judiciary, a moment to redeem themselves, that this will be historic, a chance for them to redeem themselves? Isn't it, in a way, shoehorning also the judiciary to try and sway on the way?
Surely, being given an opportunity to redeem yourself cannot be threatening anyway. It is being given an opportunity to right what you may have done wrong. Like now, we can legitimately say that the Iabc is being given an opportunity to redeem itself because it faltered. And once you falter, you get an opportunity to redeem yourself. That is not a threat. That is perfectly legitimate. Indeed, it is important to understand that in our law, it is perfectly legal to critique a judgment. What you cannot do is criticize the court, calling it a kangaroo court. What you cannot do is criticize and insult the person of the judge. That you cannot do. But if you have legitimate grounds for critiquing the judgment, then do so by all means. But at this stage, it's very interesting. I've seen all manner of commentaries, people saying why the judges of the majority of the Supreme Court were wrong and all, and they've not had the reasons. They've kept arguing their cause here and in the media, and one wishes that they had come to the Supreme Court to urge those things because their lawyers in the Supreme Court, and I was one of the lawyers there, did not say anything. They came and dismissed the petition as science fiction. They called them Pythagoras theorem. They called their own data statistics and mere data. They didn't say anything. So if any of the people out here thought that they were better lawyers than the lawyers who were presented, they should have come and made those presentations. But I can tell you, and when those judgments come out, given what was presented to court, and given the response of the Iabc and the third respondent, the president's lawyers, any rational court could only have ordered fresh elections.
Right, let's hear from Wamatangi, because last year you were here and you were very bullish that, of course, you were running for the Deputy Speaker at the Senate. Did the executive prevail upon you to step down and pave way for other people to take that particular seat? We are talking about authoritarianism, and of course, it has been alluded here that the president prevailed upon people to step down. Did he do that to you?
Why don't you let me first address the issues that were addressed by the others?
No, answer my question first, then you go to the other issues. Because that's where we began from.
I'll give you an answer. Let me start by addressing the other issues, then I'll get to that. Debarl. One, I would want to take it as just mere commentary and not really meant or intended by my colleagues here when they try to present either the NASA leadership, including their leader Raila Amollo Odinga, as in a holier than thou presentation here. And the best place to start is that time in 2013 or even before, from 2007. And remember that when we had the coalition accord in 2010 and running on now to 2013, Raila was prime minister. So when we did the elections of 2013, he was prime minister. Kalonzo was a vice president. When they went to court and the judgment was delivered against them, the words, the utterances of Raila Amollo Odinga, and sustained for 4.5 years, was that that was a rogue judiciary. Indeed, they declared every single time and every opportunity they had, outside in their rallies or even inside parliament, themselves, the leadership and all the agents, that they were robbed of the election and that they never accepted that judgment, and leading to the comments that you have just lifted. That is why Raila, preceding the time when they took this matter to court, told and chided the judiciary that they have a chance to redeem themselves. Remember, before they went to court this time, their lead lawyer, James Orengo, had declared that they are not going to court. Reasons he gave, they have been there before and they know what will happen. That is what they said before they took this one. And when they went to court, remember, they did not even go to court this time because they had confidence in the court. The answer given by all of them, when asked by yourselves, the media, as to why did you go to court, they said, we went to court on behalf of the people who could not go to court, but we know how to fix the political problems that are within and around IEBC. And going to court is not going to resolve those issues. So they did not go to court as a matter of confidence in that particular court. And if you asked me, for 4.5 years, they have sustained a barrage not only of ridicule and chiding, but also of abuse of the Supreme Court. But only this time, now when they have gotten the ruling or the judgment in their favor, have now they suddenly turned into embracing and praising the Supreme Court. There is absolutely nothing genuine about what they have said. Now, coming to some of those comments that you made, because you said the president said this, and the deputy president said that, and the agents of Jubilee and their leaders said this. Me and you know, including the lawyer who is here, Otiende Amollo, Senator, and all of us, that there is nothing that stops you from expressing yourself or your views or your opinion on a ruling or a judgment made by a court after. And those are opinions of the people. I also hold my opinion, which I'm going to express here, of that particular judgment. And so when and I'm glad you have this document here in front of us. Here, the third respondent is Uhuru Kenyatta. He was one of the parties who were in court. How on earth would you expect that he would be a party mentioned as a respondent
that we shall look
of
into?
A judge? No, let me wait a
that
minute.
We shall look
into. Wait a minute. How would you expect? No. Let me express my opinion, my friend. I'm asking, how would you expect him to be a party to that suit, and then after the suit is over, he does not find a voice to say what he thinks when the judgment has been delivered? Lastly, on this issue that was raised by Miguna on the legitimacy of his standing now as the president, unless we want to play cat and mouse with the law, we know what the law says. Until we have an election and a president installed, he is the president.
We shall look into that. We shall look into that in a moment.
On this last question you're asking, because it has also been raised by my friend here. You know, every single party holds its own parliamentary group meetings. Not only here, all over the world, in all democracies. And when you have a party that is ruling, you have within your own internal mechanisms not only the latitude but the authority to determine how do you want to proceed as a party. And so once you make your decisions, that because we are the ones who have the majority in parliament, and so it is our chance to elect our speaker or to have a majority leader, you determine.
All right.
As a parliamentary group meeting. And so on this question you asked me that I was here saying that I was going to be the deputy speaker. Yes, it is true. Actually, I campaigned a lot, including to my colleagues here, saying, "You're going to, I want you to elect me the deputy speaker." But then we went into a parliamentary group meeting, and as a party that strategizes, we sit and put our strategy on the table and say, what is our best option? How do we play our cards? Whom do we put where? And I'm a member of that party, and a member of that parliamentary group meeting. And the fact that I vied for that position does not mean that I must get it. There are other people like me.
So the president did not prevail upon you to actually
now you asked me the question. You let me answer it.
No, I just want to ask it's a yes or no answer.
And I've simply told you that in strategic positioning, we agree as a party. Whom do we front? You remember when we were here, the lineup that was all in the guess who was going to be, who was going to be, is not what happened.
All right, thank you.
So what you have seen is part of our strategy to move forward. But watch this space. You'll be seeing in the future, very near future, where I'm going. If that is the question.
All right, there is a statement that also you've said that we have never been psyched up. They called us computer generator leaders, but they will go nowhere. The margin will be historic. This is what you said in yesterday's Daily Nation. The margin will be historic. Of course, that is, we're eagerly waiting to see how that will pan out. But
it will.
Let's hear from Miguna Miguna. We cannot hold the Right Honorable Raila Odinga and President Uhuru Kenyatta on an even scale when it comes to some of the statements that they're saying, because the gravitas that will hold the presidency or that particular office is diametrically different with what the Right Honorable Raila Odinga will be, isn't it?
Debarl, let me say this. Article 2 of the Constitution says, this Constitution is the supreme law of the Republic and binds all persons and all state organs at both levels of government. No person may claim or exercise state authority except as authorized under this Constitution. The validity or legality of this Constitution is not subject to challenge by or before any court or other state organ. Every person has an obligation, that is 3, to respect, uphold, and defend this Constitution. What the president did, and Senator Wamatangi said he's the president. So number 1, the Constitution tells him he cannot challenge the Constitution. He challenged the Constitution. He says we will revisit it. He's threatening Kenyans that he's going to revisit the Constitution and he's going to either amend it or in some way alter it in a manner that would dilute the power of the Supreme Court and or the Chief Justice. And he holds a state office. The Constitution also says that that directive is to everyone. So that includes the Right Honorable, the Prime Minister. Right now, the Right Honorable Prime Minister did not and do not hold public office. But as a citizen, he must abide by the Constitution. This time around, he did not issue any threats, even concealed threats, to the court or to the Supreme Court. But the president did, and this is what we've been talking about. There are several provisions of this Constitution that the president violated. Article 73(2). It says, under leadership and integrity, authority assigned to a state officer is a public trust to be exercised in a manner that is consistent with the purposes and objects of this Constitution. 2, demonstrate respect for the people. 3, brings honor to the nation and dignity to the office. And 4, promotes public confidence in the integrity of the office. Now, the way the president behaved and has been behaving since the Supreme Court pronounced itself on this matter violates every single provision there. He did not behave in a dignified manner. He did not behave respectfully to the office or to the Constitution. He did not extol confidence in his office, in the Constitution, nor did he make Kenyans see him as the custodian of confidence or dignity. So to answer your question, the fact is this, that when you hold public office, you have duties and responsibilities that are not parallel or corresponding to an ordinary citizen. I, for example, as Miguna Miguna, I'm speaking here as a citizen of the Republic and also professionally as an advocate. But I'm not speaking as a public officer or a state officer. Therefore, the duties that I have vis-a-vis this Constitution are diametrically different from those that a President of the Republic does have. So it is wrong for Senator Wamatangi to compare the former Prime Minister with a sitting President. And the sitting President did remind us that he's sitting. So why was he doing that? That was an ominous threat, not just to the Supreme Court judges, but also to us. Remember, Debarl, that the media reported that state agents approached these judges. You know that's a criminal offense.
Yes.
But nobody has been arrested. Now, the judges said in this determination, a copy of which you gave us, that the IEBC and its officers not just refused to conduct the elections in a manner that is consistent with the dictates of the Constitution and the Election Act, among other laws. They committed illegalities. These were planned, these were deliberate, these were done with the intention of subverting the rule of law. Now, when you see the Deputy President standing there and threatening us as Kenyans that there is nothing we are going to do to change people or to remove people that have committed criminal offenses, that is a demonstration of impunity.
Thank you. All right,
and that we cannot accept.
All right, thank you. When we circle back, of course, we'll continue with the conversation with Dr. Zani and Dr. Otiende as well. Looking at the presidency right now, is it a ceremonial duty that he's holding, or as far as the Constitution is concerned, he's still the President of Kenya? Right, we'll answer that on the other side of the break. Don't go away. You're watching Decision 2017. Nonetheless, we continue with the conversation. Before we took a short break, we had to circle back with you, Dr. Zani, in regard to what we were talking about being on an even keel. The gravitas that we, of course, put on the presidency is not the same that we'll put on the Right Honorable Raila Odinga, as far as statements rolling off his tongue or their tongues are concerned.
I think the gravitas really depends on the position that somebody stands at, and I think Miguna elaborated this very, very well. I think what makes it worse is that when you exert powers that are really non-existent, and the president spoke and said that when we come back, first of all, the when we'll come back is not even in certainty, because when I hear Jubilee members talking about a majority, we are asking what sort of majority are they talking about when the judgment is very clear, the level of irregularities and illegalities that were committed by IEBC. I don't think give any side of the coalition confidence or even the power to talk about a majority. If you look at the papers today, already quite a number of petitions are coming up. I think as we're looking, we saw Senator Kivuti, who is now garnering for governor, moving with this petition. We have several petitions that are coming. The whole thing about how the IEBC conducted this election has opened a can of worms about the level of lack of transparency that was there. And we're very sure, Debarl, Article 86 is very, very clear. This election was meant to be transparent, simple, let people know exactly what is happening at various levels. So that was very, very critical. And also Article 86 stipulated very, very clearly about how the counting should be done, how the tabulation should be done. Now, a country like Gambia avoids the situation we're in by making this whole thing very, very public. And I remember as a coalition was struggling to have the adopter polling, have people be able to be there and vet, so that the polls and the votes that have come from a polling station are actually clear, accurate. Everybody can know the urgent sign. This move to the constituency, and the returning officer exactly does the same. The easiest thing for us would have been to tabulate and count across 290 constituencies and add up these. Now, the problem we have is that once you don't have this sort of transparency, there's very little you can talk about in terms of even who is there and ought to be there. So first of all, the notion that, you know, we're coming back, we have the majority and we're coming back, first of all, is a lost notion, and therefore it's misplaced, because the assumption seems to be there is a sitting president, and the Constitution is very, very clear at Article 142 that the president shall hold office for a term beginning the date at which the president was sworn in, until when the person next elected president, in accordance with Article 136(2). But then what is very clear is that at the point, because really, frankly speaking, would have had another president. For example, would have had another president if, for example, the election had been conducted properly, we might have had the Right Honorable Raila Odinga as the president. So the current president now cannot feel and act as though I'm a president continuously. Now, this whole matter is in contention, and the Constitution made it clear that this person sits till the next person is sworn in, but this becomes almost like in a position as we wait. And suggestions have been given, and in other legislators, where maybe this is a point which needs to be navigated very, very carefully. Because if you have a situation where this person feels the power that they can, you know, lash at the judiciary, they can lash at the legislator, and it is true. I sit in the Senate, and it is true. As much as we might say there is a sense of whipping, and that you can have caucuses as coalitions and make decisions about who should take what positions, in the Senate, there was a very clear contention and a feeling that here we are being whipped, specifically from a particular coalition, to have somebody coming in as the speaker. That might not be that good, really, for the Senate. And therefore, when we talk about these sort of powers that are exerted and they are forced into being put into place, we need to be clear, very, very clear, that this particular window is probably a window, even as we move on to improve legislation, is a window where we need to ask ourselves, should we then just have this particular president who already has felt this power, who feels that they can extend it, really be there? Shouldn't we be thinking maybe of a caretaker government or another group of people who are coming in, who are neutral, and move it to the next level? Because this is what will avoid all this sort of lashing. But the good thing is that in the Constitution, even with this lashing, the independence of these three arms is very, very clear. They cannot be sacked, and even as the president gives us or goes through this transition period, they go through that period with limited powers. They cannot hire certain officials, they cannot fire certain officials. So it is a limited presidency to take us to the next level. It's not like I'm a sitting president, I have the same powers as I had before. That's a misdemeanor. That is not the way the position is.
All right, let's hear from Dr. Otiende, because right now we have 17th of October as a set date to do the elections. Are you happy with that particular date, first of all?
Well, the law, the Constitution, and the judgment of the Supreme Court required IEBC to conduct fresh elections within 60 days. Ideally, therefore, that means it could be within 2 days, or it could be on the 59th day. But I think that the date of elections in this country must also be a factor, must factor in the other realities. For example, the fact that 80 to 85% of the polling stations are usually schools. And for me, therefore, it is legitimate to consider the school calendar. And if, as the Minister Matiang'i said, that it would be necessary not to go beyond 17th, I would give that benefit to the IEBC, knowing that not only must they conduct that election, from the date of that election, the IEBC chair still has 7 days to announce a winner. And therefore, in that period, basically, to take you to about 24th or 25th. If one is to argue, one would say they may have missed it by about a week or so. But for me, it's one that I can grant them. I think what's important in any event, I think there were sufficient campaigns, and there have been sufficient campaigns. And I have no doubt that in the 42 days left, there will be quite some activity. The issue in this country has been historically, not so much the campaigns, not so much the citizens queuing and voting. And I said this before elections, and unfortunately I have to say it again, that Kenyans just can't count. Everybody queues peacefully, we cast our vote, but somehow between counting that vote, transmitting it, and getting a winner, there's always a mistake. I think the challenge is not so much for us. The question is, does the IEBC have confidence that it can conduct elections within the time they have allowed, as dictated by the Supreme Court in strict compliance with the Constitution and the electoral laws? If the answer is an unequivocal yes, then I am confident. But I think that there's a lot that they have to do, and they must demonstrate that they have done before that date. And we can come to that later. What's important to note is this. If the IEBC conducts this election without adhering to the Constitution, without adhering to the Elections Act and other electoral laws, unfortunately, again, it will have to be nullified. And that would be very unfortunate.
But actually, they're going to another election, and still some things are really pending, even orders from the court as far also as the servers are concerned. You don't know about the login trails that they were supposed to give, of course, that particular evidence to the petitioner. We understand as well that was totally denied by IBC. Are you really comfortable that, yes, they can still hold this particular election, yet there are gray areas that were not really satisfied by IBC? Let me answer that in two ways. First of all, and I think that question has come in other fora and you're probably going to pose it. Is the IBC the right entity, as currently constituted, to conduct that election? The ideal answer would be an unequivocal no. But from where I sit, we have to make certain concessions. From where I sit, it is clear that the commissioners and some senior staff were either complacent or acted in connivence with those who actually sabotaged the will of the people. However, if we insist that the commissioners must go, including the chairman, then I think we will enter a constitutional conundrum. Why? Under Article 134 of the Constitution, and it's important to know that what the president said in Burma is not true. The president is continuing not as president, but he's holding what we call in Article 134 temporary incumbency. He cannot appoint a cabinet secretary, he cannot appoint an ambassador, he cannot appoint any public officer he's entitled to appoint. What that means is, if we were to cause the chair and the commissioners to leave, then we come to Article 250. The mode of appointment of commissioners is clear. They have to be vetted. It goes to parliament. But ultimately, they are appointed by the president. The president has no power right now to appoint a chair or any commissioner under Article 250. And therefore, we are in this unfortunate situation where we have to make do with the commissioners, unless one or two voluntarily resign. But if they all went, it would be a constitutional conundrum. However, the same benefit does not accrue to the staff, from the chief of executive to all the others. They do not have a similar constitutional protection. And therefore, it is legitimate to insist that those staff members who so clearly committed illegalities, and there's a litany of illegalities, and we can tell you that, including what we just spoke about. The ICT director, Mr. Mccarthy, gets a direct order from the Supreme Court in very specific and clear language, completely sabotages that process and takes the court round in a game of musical chairs, including misleading the country that there are some servers in Europe and they are asleep. To date, they are yet to comply. I can tell you that although the focus right now is on the fresh elections, there's a parallel process going on for contempt of court. Those senior officers who so clearly committed illegalities will have to serve their day in jail. And therefore, coming back to your question, I think that we must purge the commission to the largest extent possible. But we must insist that the commission does certain things that they clearly didn't do. There's a litany of things that they did not clearly do. And I've heard some people say, how do they know what they should do before seeing the judgment? The things that they didn't do are so clear, most of which they themselves admitted. I could mention at least 10 of them. But those are the things they must go back and look into. Because if they don't get it right, then this will be a null process. It's important that the IEBC takes the counsel that the courts took many years ago, about 8 years ago. The courts came to the realization that you can do something right, you can do justice. But if people don't see how you arrive at that justice, then it's not justice. Justice must be done, but it must also be seen to be done. The sooner the IEBC accepts that although it's independent, although it's mandated to conduct elections, it must open itself up,
it must invite people who can assist it, it must open up to scrutiny. The sooner it will realize that it will then get it right if it invites other people.
But given this statement that we have from Right Honorable Raila Odinga saying that Chiloba cannot manage our election again, we will not have an election managed by thieves because that will be giving our goats to hyenas. And given the time that we have right now, October the 17th, don't you think also realistically, now calling out on the Secretariat also to resign, it will scuttle the whole process? Because in light of what you're saying, that yes, you've realized from the Constitution, it will create a conundrum right now. If we send the commissioners away, of course, who will appoint other commissioners if the president also, his powers has been also stifled a bit currently. But is that also the reason why you circled back on Chiloba and not the chairman?
First of all, I think it's important. Those are not even necessarily the words of Raila Amollo Odinga. Indeed, those are the words of the Supreme Court. Once the Supreme Court finds that the body has committed illegalities, and you must remember that under the Constitution, the commission is actually the commissioners. The chief executive and other employees are merely employees at their call and beckon. The ideal situation, given this judgment, is that none of the commissioners currently ought to be able legally to conduct that election. For me, I am proposing that as the bare minimum,
yes,
in terms of practicality and reality. That we might then enter a constitutional conundrum where they have to go, but we don't have a way forward. So it is not in any way diminishing from it. But what is clear is, and I think the Right Honorable Prime Minister mentioned, there are specific officers who conducted specific illegalities which were demonstrated in court without even entering any debate. In fact, in terms of the dictates of the Constitution, they ought to have resigned immediately this election was nullified. And they ought to do so now without being forced out.
All right, let's hear the reaction from Honorable Wamatangi.
Debarl, our view is the same as has been said by all my colleagues, from the president downwards to all of ourselves. First, we said we respect the judgment of the court, but we don't agree with it. Now, coming forward to what you've just asked, especially on the date, we've been very clear. Actually, when you are quoting me there on what I said in the dailies yesterday, would have been happier with a date tomorrow, if not today. I mean, because we had nothing to hide ourselves. We went to the people, we sought votes, we didn't seek refuge in courts, and that's the same thing we did in 2013, and we are ready to go to the elections, save for a few of some of the reasons cited by some of my colleagues here. I mean, for example, what one would want to be seeing is, and ask ourselves is, what is contained in that judgment? What are the reasons that they have given per se that led to them declaring the election invalid? If it is those transmission issues, what is the real nitty-gritty? I mean, what compelling evidence within those reasons they found made them invalidate the election? Those are some of the things probably we would want to see, and we would want to say, let the Iabc say, because one thing that we must be clear about, and you heard it being said here by my colleagues, is that we do not want to give them another opportunity to run again to court, to run away from defeat in the election. I mean, this is about going to the ballot box. It's about people expressing themselves by casting a vote. Once it has been cast, the numbers are the ones which say who won and who lost. We do not want to find ourselves in another scenario whereby, because as you have seen, we have already hit the ground ourselves to ask for votes. We will continue to do so. And no matter what is said here either or outside in either legal jargon or complicating the issue, and especially in as far as the authority of the Iabc is concerned to run the upcoming re-election. That one we are very clear about. And that's why we've also insisted that in spite of the court having said that there were irregularities, the court did not point out to any of those people. And if you look at the same papers here, some of the respondents here are actually those individuals in the Iabc. I mean, people like Ezra Chiloba were mentioned in the proceedings there severally, but nowhere in the judgment that was given, or in the skewed judgment they gave at that time, mentioned the individuals. Maybe they will in their full judgment. One of the questions one would want to ask themselves is, once this judgment is concerned, is out, is IBC going to be ready then with whatever issues that are going to be raised as the reasons that caused the invalidation? And I've insisted on this because of one thing, and I don't want to repeat myself. We are very, very clear and key that we do not want to see ourselves in another scenario whereby we have gone to another election, we've gone to the people, we have won the election by a majority as we did in the last one, and then there is another loophole created whereby NASA will go to court and use either the same excuses, the same claims to invalidate an election and come up with what you have heard them saying clearly, a caretaker government. Because in our view, the pursuit that has been pursued by NASA as of now, and the reason why you're finding all these issues and reasons about individuals in the IBC is to bring about a crisis that would get us into that ultimate prize that they seek, a caretaker government. But we want a government that will be formed by the people of Kenya through a legitimate election. I don't want to get into the real content of what the reasons were or were not contained in the arguments that were made by all those lawyers who were there. Because we were here, we discussed the last time, we listened, their merits, their demerits, we have very big questions. And I want to affirm here on camera that we have not changed our position, that we do not believe that the judgment as given was correct, right, or even amounted to justice in view of what was claimed. We are very clear in our minds that the people of this country went to the ballot box, they voted for the people they wanted to vote for. There was a clear winner with a majority of votes of more than 1.4 million, and there is no argument in our view as of now that was made that either convinces us or the people of this country that any of those reasons raised about transmission of results amounted to any evidence that can be counted to say that there were any votes that accrued to the winner that should not have accrued to him as a result of that. There's no reason or any compelling evidence that we have seen from that judgment that says, although the invalidation is claimed, right, that the 8.2 million votes received by the winner were not his. That the people who went to cast those votes were not intending to vote for that person. Neither have we seen any evidence that says that in view of those reasons called irregularities, that the loser, who had about 6 million votes, would have benefited to the extent of more than 1.4 million to make him a winner out of those irregularities. Right. We are not convinced.
Be that may as it may be right now, what would you say? Because Miguna also raised a very serious issue here, that of course even as we were waiting for that particular judgment, we had government officials actually trying to call some of the judges, to try and sway their judgment. And this is on record.
I've heard that claim from Miguna here, and you see,
it was in the Sunday Nation. A report by Walter Menya.
You see, Debarl. The one thing that personally,
I've not even finished my question. My question will be, what sort of perception will that give if you're confident about this particular win? Why would you want also to prevail upon a judge calling incessantly?
That's what I'm answering you too. You don't need to finish that.
Okay.
Why do you need to finish?
I just need to be clear.
Why do you need to finish a non-issue? I mean, Debarl.
You think it's a non-issue?
We can't sit here to answer to rumors and speculations and innuendos from sources you can't quote. If there is a state officer, and I would ask my friend, I would have asked my friend Miguna or yourself.
Are you denying it?
From here, once we finish this show, please march to the office of the DCI. name that person, make the claim, write a statement, let the person be arrested.
No,
I mean, but you see, once you, and this is what we are saying. When a loser loses, they have to look for all manner of excuses and reasons. I mean, we won the election. My friend, we won in 2013.
All right,
we have won in 2017. Why do we need to go and we went to that court as winners, not as losers?
Thank you. Let's hear from Miguna.
So why did we need to go and push anybody or want to bribe anyone?
That's what we were wondering. No, and that's why you're clarifying.
You know, actually, the person, look here, Debarl, let's be reasonable. Who went to court as a winner?
All right, thank you.
We went to court as a winner.
Thank you.
They came to court as losers.
Thank you.
Yeah.
Miguna Miguna.
Okay,
That's the end of the story.
Debarl, I think the problem with my friend Wamatangi and of course, by extension, Jubilee, they are in denial. The fact is they lost in court.
Yes.
They have not accepted this.
Yes.
They must come to terms with that loss. They are the ones who lost. So come to terms with it. And the sooner you did, the better. Don't keep on meandering
My friend,
all over the place when you have lost. Number two, I kept quiet when you're talking. Number two, the fact of the matter is that the court has found as fact, and I think, Debarl, we have to be very clear on this. The only entity, the only body that finds facts is a court of law. So the only entity that has found facts regarding this election is the Supreme Court of Kenya. And they are found as fact, that those figures, those numbers are invalid. They are null and void, which means they did not exist. They were cooked up. They were manufactured. You can't keep on repeating a number that has been invalidated. The court said the president did not get those numbers, therefore he did not win. So you can't tell us, oh, he got these numbers, oh, there is this margin. There was no margin, there were no numbers, these were cooked, accept that, move on. Number two.
I would
Number two.
Speaking to yourself on
I am saddened by NASA. I have to say this after listening to my friend Otiende Amollo, because they are making very serious mistakes. They are falling into the same traps they have always fallen into. I mean, the so-called opposition. This is a trap progressive Kenyans have fallen into since 1966. The same one. And Raila Odinga has fallen into this trap 5 times. And it seems like he's very eager to fall into the trap again. So I will say this, and they better listen to me very carefully, because they are going to wail and cry and grovel after the elections if they don't fix this. You cannot gain from an illegality. Now, they went to court and they named the respondents. The first respondent is the IBC. The second respondent is the chair of the IBC. The court has found these people committed illegalities deliberately. Don't quibble with that. Remove them. Don't come here and give us excuses, oh, it's going to cause a crisis. Cause a crisis. Do you understand? Number one, remove them. Don't equivocate over that, because they are criminals. Number two, the IBC has said that they are going to conduct fresh elections in violation of the order. The court ordered fresh elections. Those elections that happened, the presidential election that happened on the 8th of August, the court invalidated the entirety of the election. Therefore, it is a fresh election, not a rerun. Not a rerun. And what the IBC has announced now is a rerun. That is in violation of the court order. So how do you expect them now to give you victory when they are violating the same order that commanded them to act? So that those two invalidations, the invalidation of the entire election, and of course the finding that these two have committed illegalities, which NASA has not dealt with. Number three, a crisis is good in politics. That is the only way you get transformative progressive changes, through a crisis. A revolution is caused through a crisis. A constitutional moment is brought through a crisis. We got this constitution through a crisis. We got this new IBC through a crisis. So why is NASA fearing a crisis? Number 3, NASA is saying that, well, Chebukati and his commissioners are the ones that are supposed to conduct an election. No, it is the commission. The commission is an institution, not people.
Not people.
You remove the people. Let's deal with the commission afterwards. After all, you can have these commissioners appointed through an agreement. Through an agreement of all the parties.
And that's the clarification.
And that is, so what you do is this, and this is what they must do. And if they don't do this, they are cooked, and we can forget about them right now. If these people don't go to court today and cite Chebukati and all the electoral officers, and they cannot exclude Chebukati. He was a party and he was found culpable. And I'm not going to excuse him for signing an illegal Form 34C and then bringing a photocopy to court, announcing an illegal result that he knew was fake. So if they don't move today for contempt of court and let the court remove these guys by saying they are in contempt, they have committed a criminal offense, and by that, by dint of that order, they are removed. Then we have to go to the next step. So what do we do now that they have been removed? Because remember, internationally, elections can be held within 30 days. We don't need 60 days. We have a lot of time. We remove these people in the next 1 week, and then the following week, we start thinking of how we replace them, and then we go to elections. It doesn't have to be Chebukati. It doesn't have to be Cheloba. It doesn't have to be these convicted criminals.
Thank you. Thank you. So expressly, I think you've clarified that, because I think there was misunderstanding also from the judgment that when the Chief Justice mentioned IBC, we envisioned it is the IBC, we the commissioners together with the Secretary.
He did not say that, so I don't know why NASA is insisting.
Yeah, that's what we're saying.
Yes.
He said the body itself, not the people within the IBC.
And he said that very deliberately.
Right. So there is a perception that you're trying to create, or you're trying to create a crisis so that we can have a Nusumukati sort of government. And this is a ploy. This is what is the narrative that is being given also from Jubilee side as well.
Let me answer that. No, let me answer that. And let me say we're not interested in Nusumukati because we're the full Mkate. We're the full Mkate. And if the election, and this is where I'm saying, this is where the conspiracy is, Debarl. And you'll remember we were in this studio every other day. When you hear the counter argument, you NASA coalition, you're always complaining, you want the IBC to be changed, you said we change, we agree. It was on the basis of ensuring that they're able to run a clean and clear election. And it was about several issues. You remember we said right from the beginning, for example, the issue of ballot papers, the issue of extra ballot papers that has not been addressed up to now, the issue of how are you going to make sure that this is transparent. All these were not answered. Now we have Chiloba there who is going to run another election. We don't know whether he already has an algorithm that has already been fixed in there so that we have specific numbers coming out. We have the issues of the server that has not been opened. We're only given the read-only version. The servers have not been opened. They haven't been scrutinized. That level of scrutiny is the level that was anticipated in Article 86.
Now, since that
no,
was...
hold on.
Yes.
Because what I want to say is very important. B, 36B, the votes are counted, tabulated, and the results announced promptly by the presiding officer at each polling station. This is the 34A. Therefore, we have consistency in the 34A and the results. These are collected. The results from the polling stations are openly, the keyword is openly, systematically, accurately collected and promptly announced by the returning officer. Now, what we saw was at the beginning of the whole charade, results beginning to stream in. Nobody has an idea from which polling station these results are coming from. Nobody has idea to verify. Later on, when the verification was done across 34A and 34B, so to look to see, is this what was actually obtained? Now, this narrative that we went and we won, it's about the figures. It's not about the figures. It's about the figures, but how those figures are meant to count, how those figures were put in for the specific candidates. If we wanted figures, we would just sit in our beds and concoct figures and say we've won the elections. Why do people line up the whole day? It's because those figures must count. Now, if you have such discrepancies, that, for example, you see a particular pattern, you find an logarithm and a regression, really, where you find a systematic way that the figures are coming in, using y is equal to ABX. You find that once you vary x, y automatically comes with a specific figure. That has happened. The other question that was asked in Kotti, nobody was able to answer, where are the 800,000 extra ballots coming from? If somebody has 6 ballots and they actually put in 1, where are the 5? That was not to be able to answer. If you have a clear, transparent election where you can stand and shout from the rooftops that we won, we have the majority, or you want nusu mkate, we're not interested in nusu mkate because we know that we have the figures. We know that we can get it all. But for as long as we have a group of people, and this is where, again, the whole issue of independence of the Electoral Commission, because we've spoken about this over and over again. But when you find in logins that seem to be biased, that you find in at various levels, there were certain things that were done. For example, papers were photocopied, not matching 34A and 34B. We want to look at those logins. Who had access to these specific logins? Did Chebukati, for example, as we explained to, a login from, for example, from Bungoma and change the results? And why was that done? Now, all this don't even need to be there. We have India, 98 million with only 2 commissioners. They run an election, in 6 hours the results are out. When you try to distort, figures will never match up. But when you start from the ground, you start with the police station, people vote, you come and say, these are the numbers, this is what you've obtained. We go to the constituency, these are the numbers, 34 Bs, they're all collected. You have your answer right there. And for as long as we don't do it, so there are 2 issues that are very, very important. 1, the figures have to match. 2, the commission needs to make that possible. And this is where the problem comes. Because the commission, as constituted, has people who have already done it differently. The illegalities and the irregularities that have been mentioned in the judgment are real. So what assurance do we have that these will not come back to us? And these are the questions we're asking. Okay. What are the reassurances? So we need to look at what is there in the Constitution. I think the notion that is being given that a commission is a commission, doesn't matter who is there. Then let us quickly move into action to find ways of ensuring that we have the credibility. For as long as we don't have that level of credibility, transparency, verification, secure, accountable, and transparent election, these issues will always be there. And that is where the problem lies. So we need to be able to really quickly be able to get to that point where we can actually have a seamless election that is transparent and everybody knows at the end of the day that this is what somebody obtained and this. And then I just want to clarify, when I talked about a caretaker government, I was talking about a transitional one, so that we don't have incumbents there who feel that they are the powers that be at that moment.
Thank you.
Nothing to do with nusu mkate, no sort of distortion should be made across those lines.
Dr. Otiende, I need you to clarify for us, because yes, we know that IBC declined to, of course, obey some of the orders from the court as far as the servers are concerned.
Yes.
So have we passed that particular junction? Have we crossed the Rubicon as it is right now? Because now they're going full steam ahead with another election,
Imagine.
Yet this has not really been satisfied. So you, as the petitioners, are you satisfied that you want to go to another election, yet this has not been implemented? And since the determination is here, what is the way forward?
Well, let me make that quite clear. First of all, the order was not just to access the ICT, networks or infrastructure. There was also a simultaneous order for the IEBC to provide what Senator Matangi likes to call the manual documentation, the Forms 34A, Form 34B, and the Form 34C. This has not always been disclosed, but the interesting thing that even the manual forms that the IBC itself purported to have relied on were not provided. For example, there are supposed to be 40,883 Form 34As, which they told the court they had all of them in the original. They only provided 40,400, more than half of which were either photocopies or carbon copies. And yet they said this is what they relied on. The Form 34C, which is the one document the chairman relies on to pronounce himself, they first brought a photocopy. Then when pressed, they brought another document which, when tested against the security feature, was not legitimate. The Form 34Bs, which are supposed to be from the constituencies, more than half of them, again, were not authentic. So that remains pending there. When the ones they brought the Form 34As, and they were only able to look at about 4,000 because they brought them late. About 2,200 were found to be unauthentic for one reason or another. Those are the numbers they keep touting. Now let's come back to the ICT infrastructure. The IEBC flagrantly refused to implement the court orders and gave very limited access. That limited access that was given revealed unimaginable things. As we've heard from Dr. Zani, it revealed things, for example, that the chairman was able to access what they had touted as, one that was impenetrable 9,000 times. It revealed a lot of funny things. And then, because the deadline was 5 p.m., at about 5:30 p.m., knowing that the court was going to ask why, and knowing that the parties had now given up and gone back to court, they used the media. And I remember getting this from the Nation Update, that the IBC now says it could not open up the servers because of the security features. Now it is opened. Then when they come to court, their counsel abandons that story and says, well, the guys in Europe were asleep and all those kind of hogwash. Now, the story on that matter has not ended. Mm-hmm. As I indicated earlier, there are contempt proceedings that are being filed. There are contempt proceedings that are being filed in the Supreme Court for those acts. You cannot disobey a court order and hope to get away with it. Now, that is going on parallel to whatever else that is going on. Now, secondly, and this is different, it is important to know that the final position on NASA on whether the commissioners go or not is still being discussed. And Dr. Zani here is my Secretary General. Whatever position we collectively take, I will be part of it. But I must venture my opinion as a lawyer and as one of those who drafted the Constitution. I think it is incumbent for me to point out whatever the decision that comes, we'll go with it. But for me, what is really, really important, and two things. One, I agree with Miguna. Once the court invalidates the elections, there is nothing to continue from. And to that extent, one would expect that they would open up the elections to any contestant, not just the leading two. That I agree with. The reason as to why they limited to the two, I am yet to see, so I cannot examine them. But for me, what is more critical than the question of who's the commissioner and who's there is, we must open up the IEBC to scrutiny. The same scrutiny that we kept pushing before the elections and which Jubilee kept opposing. Yes. The same scrutiny we are insisting on now, and Jubilee says it's an independent entity, you cannot interfere with it. That is hogwash. The Constitution grants independence of the IBC not for their own benefit, but for the benefit of the people. Because under Article 1 and Article 249, it is the people who are sovereign, then they donate their power to IBC. If the people need, and in this case they need scrutiny, you cannot use independence to shield yourself from scrutiny. The same Constitution allows public participation in the affairs of the Commission. So what I think is important is we should be debating right now, what are the measures we need to take to ensure absolute scrutiny for the IBC? How can we ensure that we have experts on elections, not observers? Experts, whether it's from the UN, whether it's from the AU, whether it's from other bodies that we can agree upon, because we know a bipartisan approach will not work right now. Jubilee does not want scrutiny of IBC. What will give us credible, fresh elections of the presidency is the IBC opening itself up to scrutiny.
Thank you.
And then we'll achieve that.
All right, so opening up itself to scrutiny, we are on the horn on a horn of dilemma right now, because yes, they're supposed to be preparing for this next election, and yet they're being scrutinized. How is that supposed to work out, Wamatangi?
Debarl, is it Harry Truman who said that that doing the same thing over and over again and expecting different results is insanity?
Albert Einstein.
Albert Einstein. You see, I mean, either purging the IEBC, replacing any of those individuals, I want to say, although we have taken a firm stand that we will not budge about that, but I want to tell my friends in NASA and to the country at large, this story being advanced that there will be a change because anybody in Iabc should be removed or be removed will not and cannot be true and will not work, because this is not the first time. And we have been here in this panel discussing this, and these people took us to the streets, destroyed property, agitated until a committee was formed, headed by one of their own, who was their lead lawyer, James Orengo, and allowed them every manner of latitude and opening, such that they should and they would be able to put in people and change the law. And that is how we came with the amendments to the Elections Act. And besides that, had the new commissioners. Barely 7 months down the line, they don't want those ones. Remember, even when we had the Isaac Hassan IABC, it was still them playing the lead role, including Hassan having been one of their own. And I don't want to impute any improper motive even on Chebukati himself now here. But remember, even Chebukati himself was an ODM candidate at one time. I mean, and nobody in Jubilee raised a finger. They've had the people they wanted. Now, at the end of this process, they don't want the IABC. And I want to tell you this, and there's a line that we are trying to follow ourselves very much, and they need to be aware that we are trying to pursue this line even after this court case. That indeed, these matters they took to court about the irregularities were their own creation. And I'll tell you why. If you look at most of the evidence they adduced in court, those irregularities they keep referring to about unsigned forms, they referred to them and they occurred in their strongholds, in Mombasa, in Siaya, in wherever. That is where the majority of them occurred. If you look at any of those issues that they raised about agents not having that, it was in their own strongholds. And we are seriously pursuing that line because it is not lost upon us that for 4.5 years, they kept on hammering the same story. They never went to look for votes from the people. They kept on saying that we know the elections are going to be stolen. The elections are going to be stolen. That was their story for 4.5 years. Only to go to court, bring evidence about those irregularities that are largely seen and known to have occurred in their strongholds. Did they create this story? Did they create those irregularities themselves so that they can come knowing they cannot win in the ballot box? Now, lastly, this story we have heard about numbers not counting. I followed those proceedings, and I was watching my good friend here my incoming senator here, friend, lawyer Otiende, Amollo. Yes, I'm a member of parliament. And I watched his argument, really. And there was at one time when Otiende introduced an argument citing numbers about how the voting went on, even in his own place. And I would want to remind them, really, that at one time in this process, they had said that they have the numbers that they will announce on what Raila attained and what the other candidates attained. But when it came to court, because that is the table where you have to prove what you are saying, they did not table this to say that this is our results. Remember, even when we came to this panel before with the other colleagues, they had affirmed certainly that they had a tallying center here in Nairobi. They claimed they had one in Arusha. They had one in Germany to collect these results themselves. And so it is true and would be assumed that indeed they had results. And they claimed to have had the results when they agitated that IABC must stop streaming what they were streaming. And they said, we know what the truth is and what the results are. Why didn't they table them? Lastly, Debarl, and I would want to ask my friend here because he was the one who is in court. They claimed, and it was also tabled there in court, that they had more than 92% representation in every polling station by their agents to look at those Form 34As. And it is also true that the matter they kept on referring to in court, the minor Kiai case, indeed is the one that set the parameters that brought about this judgment, and on the simple question that the final result of the election is at the polling station. Now, as we close this show, let them tell us, where did they lay a case anywhere to prove that any result or the results they received at the polling stations on the Form 34 itself, as compared to what they claimed is an invalidated election. That they would say in this polling station and this one and this county, we won because this is our Form 34 is, and we have these samples because they had that latitude. And so these results were changed into this. That is the whole argument.
Thank you. Let me
That's
give
the
you
whole argument.
a sporting chance for you. Thank you. A sporting
Definitely,
chance.
they cannot claim at all that they won the election. They did not. They can claim it was invalidated. It is true it was invalidated.
Dr.
But
Zani,
it was
you
a
want to
win
reply?
that had been given to a Jubilee candidate by the people of Kenya that was invalidated. Those are two things.
Thank you.
The difference is, did they win? The answer is no. Was the election invalidated with a winner on Jubilee? Yes, it was invalidated.
Thank
but
you.
the winner was known.
Thank you.
The winner was known.
Dr. Otiende, you want to reply to some of the questions that he's raised?
To, Senator Wamatangi. And the reply is very simple. Senator Wamatangi and the entire Jubilee regime are trying to argue the case they argued and lost in the Supreme Court. I have no business sitting here to argue with him, because if he wanted, he could have come and argued with me. We did our arguments and they were upheld, and they are very clear. It has nothing to do with what they keep saying. All that he has stated here are things they've created outside of the court, and I will not respond to them. There's only one important thing, and it was in court. It is clear that there were persons within IEBC who colluded with state agents to manipulate those results, to manipulate the electronic results, to manipulate the manual results by replacing the authentic prescribed forms with forged ones, by adjusting the electronic transmission to result in the regression analysis that we showed. It is important that we must get, and we know some of them, they cannot be allowed to be part of this. But quite importantly, the Supreme Court said that the elections had to be nullified because they were not held in accordance with the Constitution and the law. Senator Wamatangi here says they are sure that they will win. If you are so sure you will win, wouldn't you want the body that conducts that election to be one that is legitimate, so that your win is not nullified again? So why then are they shielding the IBC? And that is the question on which I rest.
Thank you. As we're winding up as well, Miguna.
Debarl, there are two things that Senator Wamatangi said that must be rebutted. Number one, the IBC is a public body that we all fund. It represents us, it's supposed to work for us. Even if a candidate does not have any agent in any polling station, the IBC has the mandate, legal and constitutional duty, to protect all the votes. It's not up to the candidate to work for the IBC. Number two, so this idea that, oh, you had your agents, I don't know what, blah, 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 bring the evidence. The IBC was the one to bring the evidence, not any candidate, not any party. Number two, Senator Wamatangi is suggesting that NASA was conducting the elections in their own places, the so-called strongholds. So he claims that if a form was defective, it must have been generated by the candidate or the party with a stronghold there. But the party was just a party, and the candidate was just a candidate. The only body that was conducting the election was the IBC, and the forms that were defective were IBC forms, not NASA forms. Having said that, I want to mention, because these points have to be mentioned, you did not ask me this thing about the speakers.
Yes.
But remember, actually there are a lot of illegalities that have happened. Number one, we are in a presidential system. And even in the Westminster system, the speakers are supposed to be members of the House and then elected from the House. So these are, in the two houses, speakers have been appointed basically by the executive because of the artificial majority, people who failed in an election and then appointed to head public institutions. But just because they have not been elected, has the president said they have no mandate? But look at what he says about the Chief Justice. Having said that, I must tell NASA that they must have a comprehensive audit of the IBC, the entire IBC system. That they must have. Because there is no perfect crime. There is no criminal that can commit a crime and erase all footprints and all the evidence.
All right.
And IBC has not done so. Now, Honorable Otiende said that the IBC must allow itself to be audited or brought to account or scrutiny. Institutions or persons, especially those who have committed crimes, do not subject themselves to scrutiny. They must be forced. They must be compelled. You don't expect somebody who deliberately subverted the will of the Kenyan people to now bring you everything you want and
Miguna.
open themselves to scrutiny.
Thank you. But
Yes.
I want to also, as we're winding up now, we are strapped for time, because NASA, it says, this is in the Standard, NASA to file more poll cases, and it says the National Super Alliance has indicated plans to challenge elections in 62 electoral areas. Buoyed by the nullification of the presidential election results, the opposition coalition said its team of lawyers was putting together watertight evidence before proceeding to challenge the election of computer-generated leaders. And this, you have mentioned that you have 10 isolated governors, 8 senators and 38 MP seats that were rigged. Given that now we have the speakers right now, this might change also the whole dimension of the assembly as well. Very briefly, because we don't have time. Dr. Zani, very briefly.
Yeah, thank you very much. I think that shows the extent of the illegalities and irregularities, and shows the extent to the point that even these elections and the results, as we look at them, are skewed in different ways. And this is what is giving all this chance for more people to come up and present these specific petitions. Because obviously, as this information and data is being presented, it's clearly showing that the irregularities touch on other specific positions as well. And that's what I said earlier, that even the notion of a majority might quickly be removed, because when these petitions are actually brought up, they will have to be enacted on. And we then see the face of a complete change. And you know, I just want to say one last thing, which is I think very, very important. Because even as we spoke about IBC, you know, it's not about IBC that you wanted changes, that you wanted this or that. It's about systems. It's about the people who are there, and it's about these people doing the right thing. That's why they're the first respondent in this case.
Thank you.
IBC is the first respondent.
Thank you, Dr. Otiende. Your closing remarks, very briefly. Miguna, we got from yours.
Well, for me, I really truly hope that we can get this right within the limited time. But this must be a warning. The fact that the Jubilee is grandstanding and saying no changes at IBC, as ominous as it is, means that if IBC believes them and goes ahead to conduct yet another shambolic election, then again it will be nullified. We need to get out of this circle by conducting proper and credible elections.
Thank you very much. Senator Wamatangi, 30 seconds.
Yes, quickly, just to say, on that particular issue that you've raised, that that they are going to court, and NASA is going to court, I think that the best example they would set is first by getting all the elected members to resign today from their positions. All the senators and all the members of parliament, including my good friend here, Otiende Amollo, resign. And then once they say we are leading by example, we have resigned because this was a shambolic election, we want to go now back to the one that is coming, then you believe them.
Thank you.
But they cannot continue to sit on those positions.
Thank you.
And then claim that it was shambolic. But I want to assure the members of this nation that we are going to the election. As Jubilee, we are confident that when we go to the people and make our case, they will judge us the way they judged us, that we are performing, that we are ready to serve the people of this country.
Thank you very much.
And give it a new dimension.
Thank you very much.
That's why they'll vote for us.
All right, thank you. I really want to appreciate your input this morning. And of course, this continues next week. We shall drill deeper on what will be happening so far with these petitions that we see that NASA also will be filing 65 or 62 electoral areas. So at stake also are 10 governors, 8 senators, 38 MPs seats that were rigged in the August 8 poll. So this also will be doggedly following for you. And of course, we shall be discussing this in People and Politics next week. Thank you for your valued company and sharing your morning.